kids and the dogs in the next room, and we might be able to get through this and without too much disruption. I'm Mike Whelan. I'm the author of a book called Lawyer Forward, and also I have a podcast called Lawyer Forward on the Above the Law Podcast Network that you guys can go listen to. I am hosting this conversation with my friend Jeff Kelly in North Carolina. We're talking about dealing with breaking contracts during COVID, renegotiating them, some best practices. Before we turn it over to Jeff, he'll do about a 30-minute presentation, and then we'll do some Q&A. Because we've carved out time for Q&A, I want to talk to you just real briefly about what to do with that. Before I do that, I want to invite you guys, all of this stuff that we're trying to do to give you guys more opportunities to engage and to learn is collected over on the resources page on Law Insider. So if you just go to lawinsider.com/resources, you will be able to find all kinds of stuff there. We've got an article that's real popular right now with 50 contract drafting tips, 50. So all the things you need to know about drafting contracts in one post. So go learn from those. I've also put up a series that I wrote about what it means to be a knowledge practitioner in the current world when there's just too much to know. So go to lawinsider.com/resources. All right, a couple of other points on just the way this conversation is going to go. Zoom has a chat feature. And necessarily because our group is so diverse, you guys are all over the world doing all kinds of things, it's difficult for Jeff to do more than sort of cover broad topics and start a conversation. What I hope you guys will do is use that chat bar liberally. Talk to each other. If you see something that Jeff points out that you want to dig deeper into, go start a conversation. Go over to that chat area and you guys start chatting back and forth. Make sure you tag each other, just at each other as you're responding, so you know where the conversations are going. Also, Zoom does have a Q&A feature. You see it on the bottom in the middle bar. It will share with us questions that you have. So as we go, as Jeff presents on this topic, you can just put in there questions that you have. The other cool thing that I'm going to ask for you guys' help for, when somebody puts a question on there in the Q&A section, you can actually upvote it and say, okay, that's something that I'm interested in hearing more about. We will use those upvotes to tell us Jeff really needs to answer that question. So go in there, add your questions, raise a hand so Jeff knows that that's an issue that you really care about, and we will go from there. So again, thanks, Jeff, for being here. Jeff, hi, tell me about yourself. Where are you coming from, Jeff?
Hey, everyone. So I am a complex business litigator based out of Raleigh, North Carolina, and I'd say that kind of the split between my practice is probably about 60% complex business litigation. So you're going to hear a lot of examples that are drawn from business to business transactions, although we represent a lot of individuals. And the other half of that, I do a lot of international business transactions, which will probably help me speak a little bit more to the folks that are looking at us from other parts of the world. And I'm very encouraged by it. It seems like a pretty broad range of folks that are tuning in right now. So hopefully the game plan here is to give, like Mike said, just a high level approach to how we look at different disputes and potential problems that are coming out of. Right now it's COVID, but this is universal. Anytime you're looking at obligations that are coming up and you don't know whether you or your client, depending on what your relationship is, will be able to meet the needs, and what can you do to protect them and make sure that you have a good business going forward as well. So that's really the approach here, is to kind of give you a framework to approach the problem, understand what the rights are, and gather facts to support you, and then actually approach your counterparty or parties as the case may be.
Yeah, and I'm going to give you the floor here, Jeff, for about 30 minutes, just so you guys know. Reminder, you can go in and you can put questions at the bottom and also continue a chat on the side. Jeff, what I like about your perspective is that you're doing both transactions and litigation, so you're seeing a lot of the red flags, you know, because you've seen the downside, right? You've seen the after, you've seen what happens. So I appreciate the perspective. I'll give you about 30 minutes to just tell us what's going on. I'll interrupt you if somebody says something's not clear, but broadly, the time is yours, and you guys remember to post questions in the Q&A section below. All right, Jeff.
All right, appreciate that. And, you know, Mike, you touched on a really important notion here, right? Is that so many of these lessons that we're going to talk about here, and that hopefully folks will share in the comments as well, come from the fact that a lot of deals go south. And the hope is that you don't just have the expense of, that actual deal blowing up, but you learn from it and you draw from that. So a lot of this is really me seeing contracts, on the back end and having the revisionist history and revisionist perspective of, well, if we had done that differently, if we had known that this particular judge would have ruled a certain way, then maybe that would have changed how we approach this. And so a lot of hard lessons learned that way. And I'm hoping that we can pass this on so you, if you're the client, or again, you're advising folks, that you can learn from that. So really, what is the game plan here? What do we do when we know that a deadline is coming up, when we know that our clients have some type of obligation coming due, or that we're expecting someone to come through for us? And if the past couple of months have shown us anything, you can have uncertainty compounded upon uncertainty. And I don't mean to diminish recent events in any way, except to say that when you think that you've seen the worst of it with one thing, life has a way of throwing you other surprises too. So that's something to really keep in mind as you're approaching this, is what you think in the moment may not be the most prudent path forward, but it may be your only path forward. And so what can you do to deal with the cards you've been dealt, so to speak? And so, I know this is a basic point, but when you're looking at your relationship with another party, it is crucial, before you really dig into what actually happened and what people are actually doing, to look at the actual contract term. And I don't mean to give you some basic trite response, but what I've found over, and working with a lot of different businesses, is that folks don't actually remember what they agreed to, assuming that they understood to begin with. And those contract clauses are going to be your lifeline in how you actually approach the problem. You may be looking at, how much time do I have to actually negotiate if I need to, right? So you're looking at terms that are very in every agreement, in terms of when performance becomes due, when you have to give notice. Do you have to tell the other side that this contract is going to renew in X number of days, but 60 days before that time frame, you have a right to cancel it. It may be an opportunity for you to actually get out of an agreement that would be bad for you in a couple of weeks if you didn't act sooner, or vice versa. You may have just gotten locked into another year term of something. And so these are all really important questions to look at before you actually dig into what you believe and understand. As you get to see your kind of roadmap, right? You understand, are we in North Carolina today? What part of the country are we in? And that's another piece of it too, right? Is you're looking at, we have folks from other parts of the world here. Is this a contract that, even though I'm in North Carolina, operating in North Carolina, I'm in business with someone based out of Dubai? Is there a choice of law where if we get in a dispute, I have to go arbitrate or litigate in a foreign country? And how does that affect my risk analysis, and let alone the sort of ground rules for interpreting that contract? And so again, these may seem like obvious points, but you'd be surprised how often they're overlooked, especially when you're talking about coming up with a global game plan, right? Because contracts, they may set the terms, but at the end of the day, we're looking at implementing decisions and running a business in most cases, right? This is not the part of the equation that folks are really focused on. They're looking at, how do I make sure that I have my suppliers bringing in, X amount of steel if I'm in an industrial company, and how do I make sure that I'm managing staff appropriately? And again, this is overlaid with a health crisis, right? So, talking to folks like Mike and I is not at the top of their list in terms of, okay, I understand that I have these practical business concerns, but what does that actually mean for me? And what does that actually mean in terms of my ability to do something about it? So, that's why I say it's important to not only look at what the contract is, but do you have multiple contracts? For a lot of industries, you're looking at very simple one-off transactions strung together, or even if it's an enduring business relationship. I've had a number of cases where, yes, there's a master service contract, but it's very general in terms, and really the devil's in the details of the different purchase orders, of which there are thousands. And so that's a really important piece of getting that data together before you actually go to what I consider the next step of it is, okay, we generally understand and have an independent opinion of what the terms of our engagement are. How did that actually play out? So who are the people within my company or my client that are interfacing with another party, with consumers, or whoever the counterparty is? Who's the person that actually makes this happen? And what do they believe about it? And what you'll find a lot of times is that they did not follow the exact, black letter of that contract. And that's not necessarily a problem, but it's something you need to keep in mind, because you raise lots of issues about course of dealing and performance, where that may not be a problem for you, and in some ways it may actually be a benefit but it's helpful to be able to distinguish between the two, because if you end up in a dispute, both sides are going to pick which one of those sets of rules are better for them, right? If I have an ironclad, perfect contract that, was drafted with advice of Mike and from guidance from this community, right? We know these are perfect terms that everyone loves. Well, that's great. But if I have different performance deadlines and my customer service rep has habitually said, well, it's fine that, you're going to be a few days late, and we understand. And they do perfectly normal and human things to give moderate consideration to a long-term client. Well, guess what? You have a serious problem of being able to say that they breached by not meeting certain deadlines, right? Or vice versa, where, you're in that situation and saying, okay, I couldn't meet that deadline, but you've always let me get by. And so it injects a huge amount of uncertainty into what I think is otherwise a pretty healthy and negotiable circumstance. And that really comes down to the core of the problem, which is you can pay someone like me to go litigate a case, right? But at the end of the day, there's a huge opportunity to avoid and at least mitigate costs here if you can work something out. It may not be perfect, but it's almost always going to be better to resolve something or reach some type of an amendment that makes sense under the circumstances than it is to pay and drag out a dispute for, however many months or years, depending on kind of the size and scope of it. And so that, I think, is really the best way of orienting it. So if you're working with your team, the folks that actually work on this contract and actually are implementing it, it's helpful to get their perspective on a number of dynamics that are going to affect, okay, we now know what our specific legal kind of buttoned up terms are. We now have a sense of how things actually went. What are our goals in terms of approaching this negotiation? What do we have in terms of information, relationship, frankly, leverage in a negotiation? And those are all going to be driven by the folks that actually have the relationship with the counterparties, or your clients, your customers, your colleagues. And so a few considerations on that I think are really important to look at, that are not necessarily going to be reduced to the contract, but they are going to be in very practical considerations. So the first of that would be, is this a one-off client, or is this a long-term client? And there's a couple of reasons beyond just your goodwill built up in negotiating them. If this is a long-term client, beyond, again, goodwill, this is something that, okay, look at your contract term. If you know that you want to continue to do business with them, and there's a renewal deadline that is, not too far out, but also far enough out, it may give you some comfort to say, look, approach them with this strategy of, we know that we want to continue doing business with you. And as a commitment to that, and as a commitment to some form of accommodation here, we'll extend that term. So that's something that doesn't actually cost you anything besides a future commitment. Because the challenge is, when you are looking at short-term negotiations, you're also, you're going to be doing short-term thinking. Unfortunately, the circumstances and the mentality that a lot of people in current circumstances are quite understandable. You're not thinking about your business 9 months from now. You're thinking of it, 9 days from now. And so when we're in a true crisis, and I think that for a lot of companies, especially as different relief efforts are starting to dry up to the extent they were even available, you have a lot of people that are going to be asking themselves very hard questions about what they can truly do in terms of accommodation. And so that is something that, on one hand, will bring certain people to the table, but on the other hand, it makes it impossible for people to make concessions. And I see a lot of questions, or at least a few questions, about, what do you do with people that say, I have no wiggle room, it's my way or the highway. And if that's your client and you're advocating on behalf of them, that's somewhat of your marching orders, right? You understand that they're not going to budge on certain terms. Some things that we do when we're talking with clients that have that mentality is say, okay, we understand your position, but let's think about what happens if you don't have some form of compromise, or don't make it about compromise with them, make it about a business case for them. And so the business case for them would be, if you can guarantee that this person or this company that is either going to breach on you, or, let's just assume, for the sake of this, answering this hypothetical, that they're going to breach and that they're not going to come through for you. Well, what are your remedies against them? If you go after them and sue them, are they even solvent, right? That's going to be driving a lot of decisions right now. Are you actually going to go after someone that you're going to pay someone to actually file a lawsuit, pursue it, take the time? You're going to probably take some reputational hits. And at the end of the day, they may have exhausted every last dollar that they have. So you may have a judgment that, again, great, I'm happy as your litigation attorney to have won the case for you. But if you can't collect on that, or they're going to go into bankruptcy in the time, then is that actually throwing good money after bad? And so that would be just, change the perspective a little bit. But
hey, Jeff, I wanted to ask you actually on that, if I can get you to dig into the time question, because I think what you point out with a lot of the uncertainty about what's going on and how much time you have is like, you're going to have one side who says, boy, I got to act fast. And you could have another side that says, let's just wait and see, right? How do you deal with people being on two different timelines for panic?
Yeah. So, well, and that will really turn on why are they saying I have to, one is on a super stressed timeline. And I like to attach kind of business case to that. So one example may be I'm an intermediate supplier, right? And if I don't get the part that you ordered from me, you can't do your job. And that puts you in breach of your contracts. Well, if that's the case, then asking for concessions, that's not going to solve their problem. But at the same time, you may be able to have opportunities in that circumstance by understanding that problem and framing it as, okay, do I provide a unique service, or can I actually call up my colleagues or even my competitors and get them to produce this part? So that's one thing, is you can address the problem directly. If it is something that it's really just a matter of attitude as opposed to practical considerations that could be addressed, then some things you can do to slow it down is to meet your client's timetable is enter intermediate agreements. And one thing you have to be really careful about with renegotiation, for anyone that tuned into the last panel that we talked about, kind of the fork from your piece of it, is really don't be clear about what you're negotiating, but don't waive your contract. And so what you're talking about here is we're going to agree that we're negotiating a modification. And right now we're talking about modification that is separate from the actual master contract, so to speak. And a lot of times you'll see this in the form of reservation of rights letters or other technical terms that, I mean, you can call it what you want, but the point is you're saying we still have a valid contract that you or I have breached, but separate from that, we're having a practical conversation about what do we do to fix the immediate situation. And in that, you may end up giving them certain concessions that you might not do under the master contract, but they're happy as to your sort of partial performance for this time, and it leaves you an opportunity to renegotiate or just resume the master contract without incident. So, if you're dealing with a difficult party that is insistent on certain concessions, look at how you can break up the contractual performance, make sure it's very clear that, okay, fine, we're going to bite the bullet here and do something that would hurt us if we did it as to everything, as to this one thing, and then we're going back to the original contract, or you're going to give us better terms on the rest of that because we stepped up and assumed the risk here. So, it's going to vary, and the answer may just be you're dealing with someone that's difficult, and you need to recognize that and also make practical considerations based off of that too.
Well, and I know you're getting to this, but I'm thinking about that informal, like we used to contract very informally. Usually when we're creating contracts, we're very informal about it, right? Especially when you got bill of ladings and stuff that are essentially contracts for these shipments. But how do you, in this environment, be informal enough to maintain a human relationship, but formal enough that you don't get in trouble later?
Yeah. No, and that's the challenge, right? That's why I say that technically speaking, we're talking about reservations of rights letters, and in that hypothetical. But at the same time, if you receive something that's from a clearly drafted from a lawyer that says, please be advised that you have breached contract section 5 subsection 2 that says you had to perform by this date, and while we're not waiving that right, we want to continue conversation. That's the problem. It is a red flag that makes them call up their attorneys, who then get involved. And suddenly, I mean, oftentimes, I hate to say it, but we can be as much of a problem in getting practical things done, because we're just looking at what did the contract give you a right to? And just because you have a right to do something doesn't mean it's the right thing to do in the general sense in that time frame. So, for the waiver issue, the key here is just, again, being clear that, okay, I understand that we both agreed, and before COVID or whatever it is that's triggering this conversation happened, we all thought that this was going to be fine and reasonable. And while we're being hurt by this too, we're happy to talk with you in good faith about how we might amend that agreement or how we might adjust the agreement. And so, again, the less formal you are about the language, obviously you're inviting arguments that you are, waiving. And I've seen some frankly absurd arguments about whether certain conduct was waived. So you can't completely control for the fact that you may have folks that are just looking to get out under any circumstances or under no circumstances. They're just going to claim that you waived it just because that's kind of a standard, defense that people assert as waiver. And so, but controlling for the practical majority of people, you can use slightly less formal terms. You can still talk about, but I would always frame it in terms of, let's talk about a new agreement, or let's talk about a modification, because those are still legal-ish words, but it's also making it pretty clear to most reasonable people that you're not saying that what happened is, completely off the table, but you're also trying to find what a new agreement would look like. And that's consistent with the terms of the master agreement, which usually has some type of a clause that says, no modifications will happen unless they're in writing, signed by both parties. That's a pretty standard clause that you can expect to see. And that's, I've seen arguments that gets waived even when it's not, even when you don't have modifications in writing. But again, those are somewhat of the extreme cases.
Sorry, I'm looking through questions. I'm thinking about, it sounds like practically, obviously, if you're a lawyer and somebody says to you, hey, I need a letter that reserves rights or whatever, then you've got a very formal job to do. You can go draft that. But I'm trying to get ahead of it, and I want to advise my clients, here's how you should do better with your email communication so as not to get in trouble. If I'm in that position and I want to advise clients, any best practices that you've seen in litigation for, this is stuff to definitely include in emails when you send stuff. This is stuff to definitely not include. Email is a communication tool because letters are far more rare, right, as a communication tool than emails.
Yeah. So what you've described, essentially, you're asking me, what do you do when you're advising a client, but it's still kind of in stealth, for lack of better terms, right? We're not trying to say this is an absolute dispute, but you are getting legal advice. One thing that I tend to advise clients to do is actually you're on an information gathering mission. It's not about what you're going to do. It's just help me understand what you're facing, person that's come to me with a breach, potential breach. So if your client is not actually making any representations, but they're just trying to understand a problem that they've been presented with, that is a fantastic tool to let them get more information to you. Now, if it's been made very clear that a breach is coming, at that point in time, I think it's important for your client to, with your delicate advice, lay out some of the immediate impacts that's going to have for them, and that can be a framework for discussing it rather than saying that it is, we're going to modify or talk about that yet. You can talk about what impact that has on you. So it's you essentially writing out for them from a human level what's going to happen, but also it assumes that the contract is operating.
And at this point, I'm wondering, did you have other things that you want to present it in the 30 minutes, or do you think it'd be useful to start getting to questions? How do you want to move forward?
So I think we have a number of questions here, but maybe a few last points just to maybe jog a few more folks. And again, this part of this conversation is to prompt people, because again, I'm seeing a number of questions written out in the chat too that I think are all good conversation starters. But maybe the last thing that I'd end with on kind of the formal overview in terms of reservation of rights and thinking about practical components of a dispute is that one thing that I think companies, and especially companies, but individuals too, overlook is what the cost of negotiating can actually be and what the cost of litigation is. And the fact that even if you may be dealing with a party that is 100% acting in good faith, wants to work with this out with you, a lot of companies will still use litigation as a tool. So just because you're going to ultimately, at the end of the day, work this out does not mean you are not going to get sued in that process. And that is a dynamic that I think gets overlooked quite a bit, which is when you come to the table and you start that hard conversation, can you actually afford 3 months of litigation? And if the answer to that is no, then you should be very careful about how you approach that, because again, nothing stops people from filing a lawsuit to get leverage against you, and then you have to deal with the immediate sunk cost of that. And some of this will be driven by power dynamics, where if your counterparty is a big company, that's going to mean nothing to them, but they know that hiring a lawyer, answering a complaint, dealing with some discovery as a backdrop of your negotiations, you may not be able to afford that. So a lot of this will be more practical considerations in terms of what do the power dynamics look like, and what can people do beyond just the contract that impacts your decision making.
So Jeff, one interesting pattern that I'm seeing, we've talked quite a bit, if I'm the breaching party, right?
Yeah.
I'm sort of curious about, there were questions about what kind of example am I setting for the future that they're not just going to come back. Michael asked questions that, if somebody says, if you're not living up to your contract promises now and we renegotiate, how do I know you won't come back later and try to change it again? And Jill pointed out, I'd love to hear about that from the perspective of the service provider. If I'm the if I'm the one that's actually being breached against, they're breaching, their side of the deal. What should I learn from somebody else breaching now, right?
Yeah, and it's funny you frame it in terms of the reputational harm. A lot of times, sort of the business in terms of dollars and cents element of a negotiation is completely secondary to the fact that we're talking about people and we're talking about reputation in industries, and that's something that people spend far more time and money building than anything. And so, advising the client that is in some respects innocent, right? So we'll call the person that's not breaching the innocent party, just for framing this discussion. So the innocent party is, I've been harmed by this individual or this company, but at the end of the day, because they didn't come through for me, I've now, I can't meet my downstream clients' needs or something along those lines. And so that is something that we'll need to be a little bit careful about. But the kind of 3 categories I put that in are, you have advance notice. If you have advance notice of this breach, so someone came to you and gave you a heads up that they're probably not going to do it, or you understand their operations well enough to know that they're not going to be able to come through, give your downstream clients a heads up. I mean, at the very least, show that you have taken some steps to protect not only your reputation, but what that means to them and what they mean to you. So if you take protective measures as a service provider, to not only give them as much heads up as but also let them know that you're trying to handle it, that's going to at least blunt the impact of your sort of downstream breach or your reputational harm. If it's something that you don't have any notice of, but you have remedies, one thing that you can do is work with your downstream clients. A lot of times when you're looking at supply chain contracts, their rights are going to be in some ways framed by what your rights are. And so in that sense, they can be allies. And I've had kind of small middlemen, so to speak, clients that have been able to actually pursue some pretty egregious breaches just because the big company that they were working with, they had a great relationship with, and they were willing to foot the bill of actually going after the sub. And so sometimes involving them in that as an ally is a huge boon to your clients. And so you always have to be a little bit guarded about what information you share, because you may have a common legal interest, but it's still discoverable. But again, that's something that I think people overlook, is if you know that client well enough, or that downstream individual, then you may actually be able to make it work that to your advantage. And then the third category is just, there's no relationship there. They're just going to be mad at you. There are a couple of things you can do for that fact pattern. And One is just obviously PR in the traditional sense, where you get ahead of the issue and you own it. It depends on what that is or how controversial it is, but that's one thing. Another part of kind of tying back to people file lawsuits for different reasons. I mean, a lawsuit is a public document. And so putting it out there in the public record that, subcontractor X is the reason why all of these downstream bad things are happening, that drives some of the public components of it, that in a way that I don't know that you really have an ability to negotiate, because we're just talking about reputation here at that point. So, I mean, those are kind of the three ways of looking at that.
Yeah, I want to get to Jill's question. My wife shared a story with me yesterday that a wedding photographer, that the people getting married had paid a deposit and everything was ready to go. And then the photographer had posted something about Black Lives Matter, and the purchaser, the buyer of the product said, I disagree with that stance, and so I'm canceling. And I want my money back. And the lady said, well, your deposit's non-refundable. And she said, well, I'm going to sue you, right? Which, this is a very loose relationship, doesn't have a lot of those long-term business implications. But, Jill asked the questions, what if they just say they change their mind, right? There's a general environment of unsurety. It's not that I can't fulfill the contract. I just don't want to deal with it. How do you deal with the other party breached with no apparent good reason?
Yeah. So, I mean, in that sense, you're exactly right. I can understand sort of the moral objection and dispute, but that's not what contracts are. That's not what business are directly. And so, I mean, practically speaking, if we're talking about from a dollars and cents standpoint, I mean, that's something that what you described is typically a small claims type issue. And that may be something that just you hand it off. If you don't want to deal with that, and I can understand, because we're talking about a wedding, right? We're talking about something that you already have enough that you have to deal with, a lot of other considerations. Sometimes if you're looking at what I consider a sunk cost type issue, there are a number of creditors, for example, that you can assign that to, and it's no longer your problem beyond just providing a witness statement. So, I mean, that's from the mechanical recovery piece of it, one way to look at it. But practically speaking, I mean, it is very, very challenging to look at something where you're essentially saying, I want to compel this person to actually perform something. And on short notice, no, I don't know that you could really get a substitute wedding photographer. And I mean, that's something that is extremely difficult from a kind of personal standpoint to look at. I don't know that that's something that you can work around besides covering and then trying to look at the dollars and cents part of it afterwards, just because of the nature of it. It's not something like, compelling or getting replacement goods, right? It's a service, and therefore specific performance you can't really compel, because you can't get an order compelling someone, because that's essentially indentured servitude, right? That's kind of how the case goes. So, that's a thorny one though, because at the end of the day, it hits the problem, right? Where there's a legal remedy that may give you some recovery, but at the end of the day, it fundamentally undermines the purpose of it, purpose of why you hired that person, which is hopefully once in a lifetime personal event. I mean, I say that, tomorrow's my 10-year anniversary. This hits close to home. So, yeah.
Andres Zermeño has put some interesting quotes into the Q&A that has to deal with English contract law not having a duty of good faith, right? And this gets to some of the cross-cultural international issues when you're dealing with another country that might have a different, like you talked about choice of law earlier. When you're dealing with another country, another area that might have a different view on good faith principles and what you can introduce in court, how do you adjust your informal strategy, like you talked about, to these other contexts that might have, different ideas about good faith?
Yeah, no, it's definitely something to go into eyes wide open on, frankly. That's one kind of, before we even get into it, that's something that you need to be mindful of, is looking at different, and I know that that's an easy thing for me to say, right? But I mean, that's something that you should be mindful of when you're entering into a contract with someone, especially internationally, because again, when I work with clients that are in different countries, one of the first things we do is look at, you assume the worst just to make sure that you're protected. And so what are you doing in terms of pursuing, the anticipated breaches and just kind of the standard ways that things go wrong? And part of that is a cultural analysis. One of the interesting things, since I saw a number of folks or at least a few from the UAE and Middle East, is a lot of countries there actually, rather than resorting to litigation, have a very strong global mediation approach to things. And so even if you are the kind of aggrieved party and everyone agrees you're a aggrieved party, it's partly on you to work that out with them. And so it's interesting how different countries approach good faith and resolution. And I know that was a pretty broad brush statement of it, but where that is not actionable, the question is, well, what contractual rights were we relying on in the first place? And that's so yes, it's baked into our contracts in the United States, and since we stole that common law from England, it's also to some extent there as well, the duty of good faith. But if you are looking at a choice of law in another country that doesn't have that, it's somewhat on you to look at, we've agreed to this this country's choice of law and this country's forum. Well, what does that mean to me practically? I know that those are boilerplate clauses, but they're terms that we agree to as well. And if I don't know anything about another country, yeah.
That's on me. Yeah. So Stefan Bedic, and I'm sorry if I mispronounced that, but he's asking, what is the best way to insert a provision in the contract for a possible new corona crisis related disruption or similar disruption? We talked about force majeure in a previous conversation and what's foreseeable and what's not. Is a spike foreseeable or not foreseeable for the purpose of force majeure, right? Or should we right now go to our people and say, look, we can fulfill the contract right now, but if we don't add an adjustment for if there's another spike, we could get in trouble for we're not going to be able to use force majeure later because we know now. How do you insert some of those provisions when the mess up hasn't happened yet?
Yeah, well, and I mean, not to play too cute with it, but there's an unfortunate debate about whether we've beaten coronavirus or not right now, and that's actually injects even more uncertainty into the conversation, right? Where there will be people that can point to the fact that, look, the vice president of the United States made a pretty clear declaration that we're moving past this. And so I realize that you may not be again, people can believe that in good faith. It's ahead of a nation, but so you're still going to encounter arguments that, yes, this was unforeseeable, they would come back because we relied on a authority figure to tell us that we're past it and they're in a better position than us to understand that, because we're neither operating at a national level or health experts. So who else do we rely on? So, just to push back on that one point a little bit. Now, to the prudent question of, okay, realistically, most of us are on notice that, especially in the United States right now, that things are at least not getting better at a rate that we would like them to be. I think that is a fair and diplomatic way of framing the problem. And so if that's the case, don't talk about force majeure clauses. I actually think that one issue with so much focus is because it is a unique and rarely discussed clause, but it's discussed rarely because of that reason. It's for these freak occurrences that people then argue about whether or not something qualifies. I think it's better to either lay it out there specifically, or rather than call it by its name as renegotiating, talk about assumptions in terms of your supply chain or how the service is actually delivered that would allow you excuse or build in more practically and probably more effectively opportunities to cure. So if I am the supplier and I know, like right now as we sit here, as long as things don't get dramatically worse, I'm in a position to be able to deliver by October 10th. Well, again, I know from this period that under certain circumstances, I could probably still, even under a partial lockdown, deliver 3 weeks later. Well, what if I build in a cure period, a notice and cure period, to give my counterparty a heads up that even if there's probably pretty general notice of whether or not states or countries are locked down, build in a notice period and build in an opportunity to cure. And that way you're both sharing in some of the risk, but neither party is really giving up anything. And they can also account for that into their own fulfillment, where if one of our downstream contractors, i.e. me, can't perform by this date, we agree that my performance, or sorry, contracting parties' performance is excused by X number of days. And that's something that is, it requires a bit more coordination, but I think that in terms of getting people to agree to, renegotiate in an uncertain period is give everyone a little bit of protection there. Everyone has a little bit of wiggle room as long as there's notice. And so you can plan around that.
So maybe this is a basic question, but could you do that? Would doing that by email be sufficient? I'm saying, hey, John, if things get really bad, here's what I can possibly do. Is this cool with you? John says yes. If the contract itself has something in there that says this contract rules over informal communications, which would be sort of a silly clause maybe, but how informal are those conversations for predicting the future?
So, well, for predicting the future, I mean, not that great, but in terms of the actual agreement you're reaching, and this maybe kind of to tie into one of the earlier points about being clear about your communication, making sure that people that are communicating on your behalf also understand what they're doing, is that what you just described there is arguably a modification under most agreements with only in writing, where you just in writing emailed your colleague that, hey, this is my proposal. I'm going to perform by this date. Is that okay with you? And then they, again, by a signed email, respond, yes, that's fine. So I know that sort of the internet is still this mystical place to a lot of courts, but realistically, most courts are willing to accept that an email that you sent and signed is sufficient. So that's kind of the immediate answer.
Let me get to Tiffany Eslick's question. We had in the resources section, again, that's lawinsider.com/resources. We had an article about indemnification clauses, trying to get back to using those more frequently and better. She pointed out, when negotiating indemnification clauses, what are the risks of narrowing the scope versus broadening the scope? For example, indemnity for applicable laws versus indemnifying for a very specific purpose. She says, I tend to lean towards broadening the scope while clearly stating only when applicable. Is this a best practice? How would you deal with indemnification clause specifically?
So, I mean, the short answer to that is you're going to run into litigators who are going to be creative no matter which way you go. I tend to agree with you about a certain level of breadth because the whole point of an indemnification clause is to protect you from uncertain externalities that are generally tied to a few specific events. And so when we're negotiating indemnification, we tend to keep the language about what types of acts related acts are covered, but related to what is what we're usually more specific about. And so if we're looking at, indemnifying an expert witness, for example, well, it's going to arise out of a particular litigation or lawsuit or case in controversy. And is that still a kind of vague concept? Yes, but you're also still generally understanding that as long as it relates to this dispute between these general parties, maybe not these exact parties because lawsuits have a life of their own, then that's one example. Or if it's, you're agreeing to be indemnified for, I'm going to come and clean this gym, because there was someone that was COVID positive. And so you agree to hold me harmless so long as it, from cases that arise out of that one particular event. So be broad in terms of what the indemnification allows, but you want to be clear enough about what triggers it, or else you're going to have enforceability problems.
Stefan clarified his question was about how to insert a provision in the contract for possible new corona crises. He pointed out that his question was more about recovery. I'm going to let you, do you see the overlap there for how to prepare for potential recovery?
Yeah, and I actually think that in general, indemnification provisions are challenging, right? No one wants to have to pay for someone else's externality. And so, that's going to run into the same problems of, having people breach for other reasons during a crisis. Is we're still dealing with practical business concerns about people having limited liquidity. A lot of times indemnification events are large obligations or they're open-ended obligations. And so people are resistant to that. It's going to depend on the mechanics, right? Where if this is an indemnification where I have an obligation to advance the fees, so I have to pay them in real time as they're accrued, that's going to have a bigger impact on immediate business concerns. If this is something that at the end of a particular engagement or dispute is resolved, I'm going to have a big balloon payment. You have a little bit more time on that. And really, when it comes to those provisions, a lot of times they'll be actually dictated by the indemnification clause, but being clear about what is happening along the way at least reduces some of the objections to that obligation. So if you're giving frequent status updates that are general enough that you're not giving away your strategy if it's a lawsuit, but it keeps people informed, then they can usually account or budget for that. And maybe on the flip side, drafting that, if you are the one that is responsible for that indemnification provision, make sure you're asking them for updates. Make sure you put it on the indemnified party to account for that to you, because one, that gives you an out about questionable bills down the line. Two, allows you to budget.
Let me ask a question from Anna Maria Lazar. She's talking about liquidated damages. She gives us specific context. She says liquidated damages caused by loss or corruption of data is usually excluded from liability by a service provider like a cloud computing provider. Sophisticated parties try to set an amount for the loss caused by data or corruption by data, including security breach. Maybe if you know the specific context answer to that, you might have to broaden it, but how are you approaching negotiations for liquidated damages issues when so much is unknown, especially?
Well, and I probably know enough about cybersecurity and information security to at least address the question generally. And I actually think that's a really great discussion point too, because it's something that we generally understand what data is, but as far as the mechanics of it and what constitute corruption, it is not well understood by the professional community. It is from information professionals, but from a lawyers and court standpoint, it is not something that mechanically is understood very well. So in that sense, it's a very good proxy to talk about other generally accepted concepts that are not actually understood in practice. And so it's exactly where you want liquidated damages, because it's going to be hard to articulate and it's going to be hard to prove damages, especially since when it comes to data, the downstream effect of them is so unknown. That's why a lot of regulators are proposing fines or based on data breaches that are just mandatory based on the mere occurrence of it, because we aren't equipped as courts or lawyers, generally speaking, to actually go out and measure it, nor do we have the ability to track something over the course of decades or longer. And so I think that's you're capping your risk on one hand, but on the other hand, I don't know how else to practically deal with something like data corruption or data breach, other than agreeing on the front end to what the value of that is, or intermittently agreeing on what the sort of market rate is.
I like this question from Lee Woldridge. I have a contract that was written assuming the client was ready for us to start. We didn't have a time clause in the contract. Now they're dragging their feet while we pay rent to store the finished product. They keep saying next week. It's been months. What now? There's an issue of this partial performance thing when there wasn't a secure agreement. But if you're in a supply chain, you really do have to think ahead and start preparing for things. Thoughts on how you might handle that if you've started to fulfill, but there wasn't a clear, time for start?
Yeah, so that is a tricky one for a couple of reasons. The first of which is, if you're in possession of something that is arguably, and I'm sorry if I'm misunderstanding the question too, but if you're in possession of something that is ultimately to be delivered to someone else, you can't just offload it. I mean, if you're producing it in-house and storing it, and it's the storing piece of it that is causing you the business harm, that is really where, unfortunately, if you don't have something that's like a time is of the essence or some mechanism for dealing with that, you can start to negotiate around that, or almost take the position that this is what we agreed to. And in some ways, silence in an agreement is an opportunity to really read in some of the practical pieces of it. Because if this is something that it'll depend on your industry, but if it's just an expectation that once someone submits a purchase order to you, or whatever the mechanism that had you producing it, that they would actually accept delivery by a time certain, then sometimes this will be driven, if you're in the United States, under UCC. Other times it'll be driven by default rules within that particular jurisdiction, in terms of what do you do when you're just holding the bag on something that someone else has ordered, or you just invoice it and then charge them for storing it. I mean, if the contract doesn't prohibit it, I'm not saying that that is the exact position that's going to be held up in court, but it is a position. And it sounds like what you guys are having right now is a problem created by ambiguity. So I don't know that it'd be in bad faith to give them notice of that. I mean, that may be a different way of approaching the same problem, is saying, okay, you agree to take performance or accept it by this time, and you haven't done that. So we're going to invoice it. And, as of X date down the road, so we're giving you notice, we're going to have to start charging you for storing it.
And I think, well, one thing that you and I had talked about beforehand was leases. And I've gotten questions about that beforehand. And Nancy Barungi asks, can we please have a conversation about fixed term tenancies and parties wanting to walk away from the contract? How do both sides protect themselves? Talk to me maybe broadly about property issues, in agreements for leases and tenancies and those kinds of things.
Yeah. So, I mean, fixed term agreements in general, especially in landlord space, really give you an ability to calculate damages. And so that way it is yes, if we're talking about residential leases, then it's where someone literally lives, or where business resides. But at the end of the day, the actual damages and enforcement piece of it is fairly mechanical, and it's going to be driven by states. So North Carolina tends to be, at least in the residential space, very, very landlord favored. So your ability to break a lease early is going to be driven really about mitigating damages as opposed to getting out of a lease, so to speak. That's something that's going to be about notice, really notice driven. And it's also going to be about your ability to cover. I'm going to be approaching that kind of from a North Carolina perspective, just because you're really looking at offsetting damages as opposed to excusing performance. I don't know if that was an answer to the full question.
Yeah, I'm thinking about Ken Shaw's question, which we addressed a little bit with what's foreseeable and what's not in a spike. But Ken said, I work in healthcare and have recently seen some introduction of the word pandemic into excused events, but also heard you just say that with the return of COVID, would that really be considered an unknown? So really, should pandemic be better defined in the contract to sort of, define what would qualify as such? I'm interested in this idea of what's foreseeable and what's not, and maybe that's even for new contracts. What do you think about that?
So really two questions that I'm seeing in that. One is about the specific question about if we have a force majeure clause or whatever you want to call it that specifies a pandemic, you can, even if Jeff Kelly, drafter, or whatever party I represent as one of the drafting parties, is fully aware of the possibility of a second peak or a continued peak, as the case may be, I can be ignorant of certain facts for the purpose of a contract. We can agree that this is what I understand. I can define the scope of what my understanding, the reps and warranties. And so in that sense, the contract that you described where you're seeing pandemic as an excused event being in the contract, well, then that's actually a knowing exception of it. And so that piece of it, I think, is perfectly fine. And just, you have to be careful about that, because at the end of the day, the World Health Organization declared COVID a pandemic. And so I think it would qualify for that. To the practical piece of it, let's say we're not having that contract provision, or we just have a generic, act of God clause in there. It's still, even if it's foreseeable now that a pandemic could sweep through and completely decimate supply chains, cause people locked down, and frankly have unintended consequences right now that we're still figuring out what they are, that could still be an act of God going forward. I mean, we know that hurricanes happen, and yet a lot of times those are excused as, I know it's not an exact comparison, but we're willing to accept that. I live in North Carolina. We get hit by hurricanes. We get hit by them fairly often. And yet that can still be, qualify as an act of God for certain contracts. So foreseeability, I mean, it's better to define your terms and define what God will or will not do, so to speak. But, saving that, or saving the creativity, I think that just because we've encountered it doesn't mean that it's no longer going to qualify as an act of God.
So Michael Purvis asked the question, which I might say we've talked a little bit about this, but he said there's been no discussion about the psychology involved in such renegotiation and the interactions of the party that's a part of the process. Could you discuss that? Maybe, I'm thinking about lawyers are often used as sticks by people who feel really insecure, right?
Right.
So they'll just call my lawyer because they just feel out of control. So talk about that from, trying to get the client to step back and say, you playing the bad therapist, right? Let me get behind what you're really asking, client. How do you deal with the psychology of clients and opposing parties?
Yeah. So for your client side, and maybe this has to do with the general approach that I could spell it out a little bit more. So part of why we take a step back when we work with clients and talk about what the black letter says, and then separate that from what actually happened, it helps you understand a little bit of the dynamics. And it's two pieces of what going into figuring out what your client's actual goal is before you even go and talk to the other side. So I think that you're exactly right, that the central question in any negotiation is really, what does your client want out of it? And also figuring out what the counterparty is willing to accept or what their goals are. Because I'm trying to think of the example I gave at the head of the webinar, but thinking about the clients that come to you and say, we have a pressing need, right? Where there's a complete gap in terms of party A is just chomping at the bit to get this done, and party B doesn't understand what all the fuss is over. And so what could be motivating party A was the fact that they have performance obligations that they can't actually meet but for your client. And so in that one, it helps to think about what their mentality is, where they're coming from, because part of the solution may be, for this one particular segment of the contract, we're going to work with competitors or colleagues or whomever to fulfill what have been our obligation that we can't here, and then we're going to get back to it. So, I mean, that's, I know, a very quick and simple example for what is usually a very complex dynamic, but that's really the general approach, is understand why they're acting the way that they are and see if you have a solution that might fit it.
Here's one that I'm actually curious about myself. If I've got a super long contract, Tanveen gives the example of a 20-year contract with no termination provisions. These things that happen that are unforeseeable, well, when you're talking a 20-year timeline, crazy is going to happen somewhere. How does that commercial reasonableness, apply to something? If I've got a longer term contract, should I have been more aware of something crazy is going to happen during that period?
Yeah, so I think that the general idea that, yes, we have a hard time foreseeing certain things. I mean, even look what technology looked like a decade ago, right? And so that's something that, setting aside other geopolitical aspects in play, is you're really assuming the risk of this. So I mean, I hate to sound a little bit cynical about this, but by entering into such a long range contract, in some respects, aren't you agreeing that the parties are assuming their respective risks? That maybe if you believed that, or you were more risk sensitive, that you might have, this is for a 20-year term, but at year 10, we're going to reevaluate these particular rates. I mean, just because new things happen or extreme things happen doesn't mean that you can't look and assume that rates are going to change, sometimes precipitously, or that it may be something that you wouldn't understand, that the whole purpose of the contract was undermined. In that case, yes, you may have an ability to excuse it, but I think over 20 years, you're probably assuming a lot of risk.
Well, I appreciate that. You guys, we're going to wrap up this conversation. There's a lot to talk about. I hope what you guys will do is continue to ask questions. As soon as this survey is, or this webinar is over, a survey will pop up that you guys can answer that will help us know what you liked about this. What do you want to see in the future? There's an open-ended question about what more do you want to hear from us, right? What more can we address to be useful to you? So I hope you guys will answer that survey. And again, go to lawinsider.com/resources. We're going to continue to share stuff in multiple formats there. And I hope you will become contributors. If you've got things to say, things to share, we're trying to build a community here. Look at the bottom of those posts. There's an email there for you to send to become a contributor. Jeff, thank you for joining us. If people want to follow up with you, maybe get some more ideas, maybe talk to you about super complicated international leases, what's the best way to get in touch with you?
So if you want to look at law and technology, probably the best thing is Twitter. That's one of my kind of pet projects, and that's JeffK_NC. Otherwise, shoot me an email or connect with me on LinkedIn. And my email address is jkelly@shanahanlawgroup.com, SHANAHAN lawgroup.com. Very long one, but
it's a lot of consonants,
you know,
buddy.
Google my name. Google my name.
Thank you, brother. Thank you, guys. We'll see you at the next one in a couple of weeks. Have a great day and a great week. Thank you.
All right. Thanks, everyone. Take care.